Sensational Saturday. Welcome once again to another exciting edition of the D Word with me. I am your host, Furley Almonte, with my co-host, the beautiful Carolina Denhard.
Thank
I'm
you. Good morning, everybody.
very, very good. And today we have a special guest who is going to actually open a lot of our eyes and our possibilities, actually our possibilities to what is available to us and what our rights are when it comes to employment also and labor laws in the middle of pandemic. But first of all, and also Carolina is going to touch upon a very, very nice topic that could also be related to both divorce and labor laws. So first of all, let us get a little background on our special guest, because we like to brag about our special guest here at Divorce Dynasty. Well, Joshua Weiner is a partner and chair of the firm's Employment and Labor Law Group. Joshua has significant experience in employment and labor, representing small to large companies for employment law needs. Joshua works closely with clients in litigated matters, as well as administrative and arbitration proceedings, employment and preventative practices and audits, labor union law disputes, wage and hour claims, and management training. Prior to joining Coughlin Duffy, Joshua served as chair of Employment and Labor Law Practice Group and the Litigation Division of the Bud Larner. Joshua has practiced at the law offices of Weiner and Weiner, an employment and labor law firm co-owned with his father, Paul Weiner. Wow, it runs in the family. Special counsel to Coughlin Duffy. Well, he also represents both the employer and the employee, and he also includes claims of discrimination, harassment, whistleblower, retaliation, wage and hour disputes, defamation, and invasion of privacy, among many others. Well, obviously, we could not have gotten a more genius when
Please.
it comes to employment and labor law, because that is what Divorce Dynasty is all about. Welcome, Mr. Josh Weiner. Woo-hoo!
Thank you very much. Good to be here. I didn't know my resume went on for that long, so it's actually kind of humbling to hear. But thank you. I'm very happy to be here.
Now,
So
Carolina.
I want to first of all welcome Josh, and it's Weiner, which I make fun of him all the time.
Oh my gosh, I apologize for that mispronunciation.
Furley, it's
No.
perfectly all right. People always say Weiner. They'd rather say Weiner and get it wrong than say Wiener and get it wrong. But it's Weiner. It's perfectly all right.
But Josh and I go way back, so I'm able to make fun of him all I want. Furley, as you read, Josh is a former partner at Bud Larner, where I built my career as a matrimonial attorney. And when the firm unfortunately closed its doors, Josh and I went to separate firms, but nevertheless continue to work together. We were very fortunate to have Josh join the Divorce Dynasty platform, because there are often times when divorce interacts and intercedes with employment law, especially when married couples own a business together. So imagine getting divorced because you no longer want to stay married, but now you have this company that's been supporting your family throughout your long-term marriage, maybe generational company, and you now need to divorce that too. So although we don't think of companies coming apart or being put back together creatively as divorce, it really is. And Josh is our go-to, not only in that area of the law, but also for all of the labor and employment needs of the individuals on the platform and of the clients that use the services of Divorce Dynasty. So we're very lucky to have you on this Saturday. Josh, what's happening in your world right now? I was just coming to work this morning, and we are on the eve of an election, right? And there's so much enthusiasm but concern out there. Businesses are still closing. We're talking about a second wave of COVID. What are you hearing?
Oh, a lot's been going on since COVID hit. There was two major pieces of legislation that was enacted by Congress. There was the Families First Coronavirus Recovery Act, and there was also the CARES Act. And both have impacts on the employment realm. The first part on the FFCRA is that you have additional paid leave as well as additional medical leave for coronavirus related reasons. And there's a whole panoply. So I got calls from clients from all sectors asking, what do we do now? How do we implement this? And the truth of the matter is, this was enacted so quickly by Congress that there was really no guidance. And so a lot of employers came to us asking for what do we do? And it was really a little bit like shooting in the dark. It was very difficult. We were able to get our hands around it. Fortunately, most of the things settled down. But now that they're expecting that second wave of the pandemic and how that's going to possibly impact on that business moving forward, and also on the employment realm, the industries that have been hit the hardest are hospitality. Hospitality is one, an industry that I represent a lot of. And the summer more or less saved them because they had outdoor dining, people were coming back, but they were really just staying afloat. They weren't growing their business. They really weren't making money so much as they were just able to hold the fort. And we're kind of just holding our breath, one, to see what's going to happen if and when the second wave hits, and also whether Congress is going to be extending the protections that they provided earlier in May and March and April. And right now, we don't know. It's supposed to expire December 31st. So right now, employers are scrambling, saying, well, what are we going to do if Congress extends it? To what extent are they going to? And if they don't, what do we do? And it's been difficult. It's been very difficult for the clients, and it's been very interesting for the attorneys trying to go through this minefield.
One of the things that a lot of our clients that are going through divorce are also bringing into the conversation is the fact that they've been laid off, right? So we're in the middle of negotiating a divorce deal. Somebody had X job, the alimony, child support, extracurricular, et cetera, was based on that cash flow. And now somebody was laid off. And the questions have been, do I have a right to sue? Is this, have I been laid off legally? What happens? And initially when this happened, the questions were, well, they can't do that to me. I can't be furloughed. I can't be this. Can you speak to that? I mean, obviously, does the government have a right to now, for reasons that perhaps would not have been lawful before, to terminate, suspend, furlough, et cetera?
Yeah, employers, we have employment at will in New Jersey, New York, and throughout the country, meaning that, and it's a mantra I go over with clients on a daily basis. You can be fired or laid off or furloughed for good reason, bad reason, or no reason at all. And when people hear that, they get kind of shocked and they get scared, because you could be at a company for 2 days or 30 years and your rights are the same, no matter how long you've been there. Even though after a certain period of time, you might have bought goodwill and maybe what we would call implicit tenure with an employer. That's not necessarily the case. So yes, you can be furloughed, you can be laid off. There's a lot of issues with respect to the extended unemployment and how that applied to them. Unemployment's still on a backlog, and people that were supposed to have received it in June, July still have not received it. But yes, you can. But interestingly enough, one of the things that's come up actually most frequently, and I think that is applicable to those in the midst of a divorce and especially families, is that Congress carved out a special exception under the FFCRA that basically enabled extended leave, basically creating a new category of family leave for any parent who has to stay home with the child because of a lack of daycare or school. And not only that, you also get paid at 2/3 your rate for it for a period of up to 12 weeks, which was a new category that exists as of right now. And that's something that a lot of people didn't know about. Because it came out so quickly, individuals didn't really know what their rights are. So that my job for the past half year has been kind of advising people and instructing and educating them on what their rights are under this new legislation.
Yeah, you know what? That's very, very interesting, because I know a lot of people who are now in the midst of turmoil at home because they need to go to work because their job requires them to be present. For example, the healthcare. In the meantime, because of the hybrid education system that we have right now, people are not able to go to work because now they have to worry about childcare. So now a lot of them will be forced to resign. Is there such a thing as constructive discharge so that people will willingly leave their job because of this situation that they're in?
Well, constructive discharge is a thing that exists in the law, but it's usually when an employer, it's very hard to prove. The burden's very high, and it usually comes down to a situation where the employer leaves the employee no choice but, as they say, joining the ranks of the unemployed, making the work environment so hostile for a discriminatory or retaliatory reason that the employee was left with no choice. When it comes to COVID and this pandemic, ultimately, I've dealt with the situation where employers are like, look, we need you to come in. Now, the office environment under Governor Murphy's executive order still says that if you can work from home, you should be required, you should be allowed to continue working from home. And that's mainly in the office setting. But in other industries, hospitality, retail, kind of any brick and mortar setting, they're saying, look, you have to come in. You can't work remote. And the unfortunate part is that in most of those instances, if you can't come in, the employer can lay you off. However, if it is for a reason, because my child is working remote, there's all virtual school, or it's some hybrid session, and I can't come in as a result, the FFCRA does provide them leave. However, that leave is only temporary. And right now it only exists for a max of 12 weeks. So this pandemic has been going on for the better part of 7 months. They believe it may go on for another year. So what do you do in those instances? Well, employers have been left with very little choice in some instances, but to get rid of those employees. Now, the problem for those employers as well is, are we going to be able to rehire someone who wants to come in, who's able to come in and isn't fearful of possibly contracting coronavirus? So even beyond the law, employers are having a hard time filling those positions because people are like, look, for $12 an hour, $15, $20 an hour, I don't want to risk getting sick, getting my children sick, or even in mixed households where you have grandparents living with them or older relatives. I don't want to get them sick because for some of them, they might consider that almost close to a death sentence. So it's going and it's transcending the law, and it's affecting people on all different levels. And the law is trying to catch up. The problem is that there's only so much you can do.
Yeah, and to segue into how this impacts families that are now unfortunately falling apart. And we've seen a rise, unfortunately, in domestic violence and divorce law since the pandemic, because people that were somehow going through the motions and they had a lot of extra external stimuli, whether it's busy traveling on business or going to the office or commuting. Now everybody's home and they were forced to deal with issues perhaps that they didn't want to deal with, which would have been some marital issues. So as marriages are falling apart, as people are filing for divorce, those families that have businesses to value, that are family businesses, have a twofold problem. One is that business going to be impacted in value because of COVID. Obviously, depending on who you represent, somebody's going to say, well, it's a temporary setback, everything will go back to normal, and let's take the highest and best, which obviously we can't say anymore because we don't know about the second wave, and we don't know what's going to go back to the old normal, the new normal. Who knows? We don't know. Secondarily, we need to talk about what happens with these companies post-divorce, especially when both spouses are employed by that company. So, Josh, you and I have had some cases like this, and they certainly bring about additional challenges. Do you see these cases becoming more difficult now that we have the wrinkle of COVID?
Yeah, I do. Simply because, and into your field, it's going to be, well, who's going to take care of the kid on which hybrid day? If they continue the hybrid learning, when's it going to end? What if all of a sudden, and this happened, it's happened in my town only for a period of about a week, but if there's an outbreak and all of a sudden kids that were in school now aren't in school and they're not allowed to go into school and it's virtual. And if you have young children, I have two. I have a 7-year-old and a 10-year-old. My 10-year-old is fairly self-sufficient and she's pretty good online. My 7-year-old is a 7-year-old boy. As great as he is, he's a 7-year-old boy. And yesterday, for instance, my wife had her day off from work. We've been working from home. She had to run multiple errands. I said, okay. She came home about 3-4 hours later and she said, how's it been? And I go, fine, but I've gotten no work done. And I couldn't blame my son. It's not really his fault. And then all of a sudden my kids needed to eat and I had to help them and feed them. And this is something that's going to impact. And this goes beyond just the law. It's like, well, and if you're going through a divorce, who's going to take care of the kid becomes a huge issue. And where are you going to drop them off? Is it a safe setting? But in the employment realm, it's been a bit of a cluster. It's been very difficult on both the employee and the employer end. I represent some small businesses, and they're like, look, Josh, we're bound by this law that Congress enacted because it doesn't matter how many employees you have. We're trying to do what we can, but we can't survive.
Right.
And some have had to shut their doors. For right now, they think it's temporary. They don't know if it's going to be permanent. And they go, well, and if it's not, so the employees that they've hired or that they've laid off or furloughed are still like, well, are we coming back? When are we coming back? And if we do, is it going to be at the same pay that we were originally paid? So it is really an open-ended situation, and it's so dynamic. in the law, Carolina can attest to this, you know what the law is when you're proceeding with the case. You know what the case law says. You know what past precedent is dictated. You know this judge and what they're going to do. Right now, we don't know. And even the larger firms and the big wig, big shot, blue chip attorneys, who I know many of, they don't know what's going on. It's guesswork. It's playing shooting BBs in the dark. You don't know who you're going to hit. You don't know what the end result's going to be. You can guide and you can have a good sense of it, but at the end of the day, you don't really know. And it's difficult as a counselor at law. In Carolina, in matrimonial law, you do a lot more counseling than you probably do on my end. And you try to assuage the client, allay their fears, make them feel better. And I've had to tell clients on numerous occasions, very dishearteningly, I don't know.
Right.
We're going to get through it, but I don't know.
Question for Carolina. Carolina, for divorcing parents, right? Like if, say, for example, both of them are doctors, how do you decide who actually has to give up their hours, their wages, because, they have to take care of the small children?
Well, nobody wants to give up their wages or their hours, I can tell you that, because that has all sorts of ramifications in a divorce. But we are really thinking creatively for the cases that are currently pending, because not everybody has a caregiver to come into the home and care for the child to allow the parents to work. Daycare centers, for the most part, were closed for a very long time. When they opened, they did open, but the hours are limited. There's so many restrictions. A lot of families, to Josh's point, have elderly parents living with them, so you're afraid to bring somebody else in. So it really is dictated, one, by, are somebody's hours getting cut by the employer, where there's no conversation to be had because they're cut because that's what the employer decided. Or two, if people are self-employed and they run their own company, their own business, then, although they're divorcing, we try to sit down and come up with an interim parenting plan. It's, whether you're still in the household together or you're already living apart, how are you going to shuffle the kids back and forth? What's become very difficult is that if somebody lived in Short Hills and now someone moved out and rented in Jersey City in a high rise while the divorce is going on, interim apartment, a lot of our Short Hills women didn't want the kids going to a very high infested area of COVID, such as Jersey City, for example. So every situation, Furley, I can tell you, has layer on top of layer on top of layer. And now that we have this hybrid homeschooling, it's become even more difficult because the kids have to log in, right? People have to, dad or mom, depending on the age, have to be able to support them. And if mom or dad have a job that requires them to be logged in because their keystrokes are measured by their employer, for example, then they can't do both at once. So now you're maybe limiting somebody's parenting time because they have to log in keystrokes and they can't watch the child. It's something that, as matrimonial lawyers, we've never seen. And to Josh's point, judges don't know what to do with this yet. It's new.
Yeah. And what do you do in a situation when, if, it's one parent's time with the kid contracts, or the parent might contract COVID, or their friend did, and now you have to isolate, and the other parent's like, well, it's my time this weekend. It's like, well, we have to isolate. You can't see the kid. And judges have to be mindful of that fact. There's a public health crisis, regardless of what a custody order may dictate.
Right.
It's like, but I can't send the child out into the wild, so to speak, put you at risk and possibly your coworkers at risk. It's quite frankly something that I've never anticipated would come in my lifetime. But the good news is that every lawyer is going to be mindful. Hopefully it doesn't happen in our lifetime of a next pandemic. We'll have this whole body of experience to work off of going forward.
Yeah, it's really, it's crisis management, at its best. Yeah. Josh, I want to, Furley, you work with your wife, you run a business together. Yeah. So many people are married to someone that they actually run a company with, whether it's a store, restaurant, or what have you. Josh, what are some of the things to consider when you are working and running an operation with your spouse when, unfortunately, divorce falls upon the family?
It's a tough one. I think we experienced that at Bud Larner, and where it was individual ran a small company, and his wife was the bookkeeper, and really wore many hats, but the bookkeeper. And ultimately, they had a falling out, and they were going to be getting divorced. And the employer, my client, found that the wife was stealing from the company, or believed that she was stealing. And he was, well, what do I do? And I go, well, let's be clear. is this really a situation in which you believe that your wife was stealing, or are you just angry that you're getting a divorce and you want to get your revenge? Because that would be problematic under the law. The New Jersey recognizes marital status and familial status as protected categories. So if you're getting back at your wife because you're getting a divorce, I'm going to say it's a no-no. And he said, no, I have it documented. He showed me. I go, this looks kind of bad. And I remember he laid off the wife, and I got a letter from an attorney a week later, but I kind of showed him what was going on. I laid down the law, and we were able to work out the situation. The client was very pleased with the result. But when you're working with a spouse, you're talking about two separate relationships. You have your work relationship and your marriage, and they get intermingled. It's inevitable. And it's difficult because just like you never expect a job to end, you never expect a marriage to end. And like jobs and marriages, they have a tendency to end. I forget what the latest percentage is. I'm sure Carolina knows, but a lot of marriages don't end successfully. And probably most. There you go. One out of two? One out of every two. So 50%. You never keep the same job the majority of your life. So that percentage is probably even higher. And, what I tell clients is that, look, if you're entering into a working relationship with your spouse, there's two ways in which you can go about it. You can do what you think is best for you and basically play it out the same way you do with your marriage and let it just be. But that could be problematic. Or you can enter into an agreement. You can enter into, in this instance, an employment agreement. You could probably, and there might be some way of entering into some type of hybrid that could be deemed a prenup, or it wouldn't be a palimony agreement because that's only if you're not married, to kind of work out what would happen if there was a layoff, what would happen if there was a divorce and a layoff. Those are complicated, and they kind of have too many aspects of the law interacting. So what I always suggest is, if you're going to do that, be mindful of the fact, and this is obviously something that people don't like to acknowledge, is that there's a good likelihood that either the marriage or the employment relationship may end in the next 10 years or 15 years. And if that, I'm sorry, but when that happens, it's not going to end well. I don't think Carolina's ever seen a friendly divorce, and I very rarely have ever seen a friendly end of employment relationship. Now imagine if both are going on at the same time.
Yeah.
Well, actually, there is a question from one of our audience members about somebody being forced to retire early. What happens to the benefits? Can you talk about that? Well, from a matrimonial standpoint, Carolina could actually, from a COVID standpoint, like a business that is going through financial hardship, and now they're asking the more senior employees to retire early. They were being forced to retire. It could become problematic if it looks like that more senior employees are being forced to retire or pushed out. That could be an age discrimination claim, depending on the rationale and the reason that the employers are utilizing to do it. If they're doing it because they think, well, we don't want these employees to be at higher risk, and we think that they're a liability, that could very well be an age discrimination matter. I'm not saying that it is, but it could be. If they're doing it because it's just a standard practice and they hand you a severance agreement and say, here you go, we're giving you early retirement, enjoy. Well, one, you want that to be looked at by counsel because there's certain requirements that such severance agreements have to have under federal law. In terms of benefits, if they're not handing you a severance agreement, if you're talking about health benefits, there's COBRA that covers that for right now, meaning that when you lose your job for a qualifying reason and you're under their health plan, you can continue that health plan under COBRA, which is federal law. The problem with COBRA is that you're now required to pay for the entirety of the plan.
It's very expensive for the most part.
It's extremely expensive. It's a family plan. It could be well over $1,500 a month. I've seen individual plans that were individuals who just lost their job, mind you, now have to pay close to $1,000 a month to maintain their health insurance. And that's obviously sometimes not cost effective. So then you're like, well, can I go under Obamacare and see if I can get it? Well, we don't know what the Supreme Court's going to be doing with that in the next couple of months. So now that's up in the air. And that's also, that's a federal legislative issue where people now don't know where they're going to get their health care necessarily. But you do have that option. If it has to do with PTO, paid time off, depending on how the employer does it, you may or may not be entitled to a payment for your unused but accrued PTO. There is no right to that in the state of New Jersey or New York for that matter. If your employer has a policy of paying that out, you probably would be entitled to that from a contractual basis. But ultimately, if they're pushing employees out, what I would do probably is speak to legal counsel, get their guidance so the attorney can determine, well, let's see, is it just you? Is it other similarly situated employees that are around your age? Are they offering you severance? If not, why? What's the employer's reason for it? And if it looks like that older workers are being targeted, it could be or could constitute age discrimination. But obviously, I can't say that with any certainty without looking at it. But it certainly is something that you should be mindful of, and you should seek legal counsel and get their advice before signing anything.
Now,
Well,
for
do the employers right now have a lot more protection to lay people off and do these types of things that Furley is describing because of the pandemic?
They don't have more rights. Their rights are what they were before. I mean, the scales are the thumb is on the scale in favor of employers, always have been. I always say to my employer and clients who think that the employees have it better, I say, well, that means the law might be getting it right, because the truth of the matter is employers have the upper hand because it's employment at will, which I always tell employees, hey, look, it means you can leave for any reason you want, but good luck trying to find another job. So it's a lot easier for the employer to fire someone than it is for an employee to just leave and then try to find a new job. So it's not, it doesn't provide any more rights or incentive for employers to get rid of employees, but it does provide a new wrinkle to the analysis. If an employer is saying, look, my older employees are more at risk, they're more susceptible, I don't want them to be out on extended leave because if they get sick or a family member does, so we're going to do this to cut costs, but we're targeting older employees as a result, that would possibly be age discrimination, because the motivating factor there seems to be dictated on age as opposed to any other factor. And COVID does add a new wrinkle to that, because certain people now are more susceptible to the virus. If you have a pre-existing condition, if you have an underlying disability that makes you more susceptible to a bad COVID case. I got a call recently from an individual, and her doctor called me as well saying, look, my client doesn't develop antibodies to COVID and has had it 3 times. And all of a sudden, it now was not a COVID situation. It was like, well, this person has what would probably be recognized as a disability, an immunocompromised disability under the law. And so the employer probably has an obligation to provide what we call a reasonable accommodation, or to attempt to provide a reasonable accommodation to the employee in light of that disability. So disabilities that may not have been an issue previously, or age-related issues that may not have been an issue previously, now are in the face of COVID. So COVID is now magnifying that which already existed.
Interesting. So it's
what 3 tips would you give people who are watching right now, scared that they're on the verge of losing their jobs? What should they be looking for? What are the telltale signs that they will soon be axed?
It's a good question. I always say there's no definitive sign, but if you're starting to get assignments taken away from you, responsibilities, if you're kind of being pushed out to the pasture and now they're not calling you when they used to call you, if when you used to get that call to come in an emergency and you're no longer that person, those are probably good indicators that they're either looking to hire someone else or they're going to be letting you go. If the employer tells you, we're having financial problems, that could be an implicit sign where the employer is saying, hey, look, you may want to start looking for other jobs. But it doesn't necessarily mean that your rights will go out the window and that you don't have any. If you feel that you're being treated differently than others because of some protected category, either because you're a whistleblower. I've had situations lately where employees have said, look, we're not throwing around PPE the way that we should. You're not having mandated social distancing or protecting our health or our safety and welfare as employees. And you feel that you're being retaliated against as a result of that. That could constitute retaliation under New Jersey law. It could also constitute retaliation under OSHA, the Occupational Safety and Health Act under federal law. And that's something that you very well may need to look at. And I always say, if it quacks like a duck and it looks like a duck, it very well may be a duck. And what you need to do is you need to contact legal counsel, or even if it's someone in your family who is an attorney who could point you in the right direction, to get some advice on what's best and the best way in which to handle it. I always say also be mindful of the FFCRA, the Fairness First Coronavirus Recovery Act, or the Families First, not Fairness First, the Families First. Type it online. Your rights are dictated on there. The type of leave that you would be entitled to, the paid leave that you would be entitled to there is there. It's a little complicated. It's written like stereo instructions. If you're confused, contact an attorney, have them guide you in that way, because employers, although they're required to, are not going to say, hey, by the way, here are your rights under the law. They try to avoid that and ignore that because they hope to, one, they may not know, the employer just doesn't know, or they're trying to avoid it. So understand your rights. And I say this to people, the internet is a wonderful resource. It's not the be all end all. It might give you a general overview, but you don't know who's writing it. You don't know if it's accurate. So please contact legal counsel to guide you, because there's a lot of laws, there's a lot of exceptions to the laws, and you want to make sure that you're on your right footing. And you also want to know what your rights are.
Gosh, where were you many years ago? And I'm listening to you right now. It's like, oh my gosh, where was he? Like, because there have been 3 instances in my life that I could have used you, but I did not pick up the phone and consulted with somebody.
Yeah, and it's key. It's Furley, it's a very good point. People don't think about it.
Oh my gosh, I could have been protected by somebody like you. What will people like me, who probably have doubts of, like, I felt like I was discriminated or unlawfully let go? So what would they do? What kind of procedure do you have in terms of them consulting with you? Is there a fee to talk to you? What's your protocol?
Well, in the light.
Before he answers, anybody that calls Josh on behalf of Divorce Dynasty, right, gets top-notch VIP treatment. That's what the platform offers. So I know that for anybody that's watching the show that calls Josh on Monday or next week or in the future and says, I saw you on the D Word with Caroline and Furley, Josh is your guy and is going to treat you great. But Josh, go ahead. How can people reach you, and what's the procedure?
Yeah, the way I used to do it, and I say pre-pandemic, is that normally I would speak. I don't charge people for talking on the phone. If you're giving me 15, 20 minutes of your life, the least I can do is listen. The least I can do is to try to get a brief Cliff Notes synopsis of the situation. Obviously I can't give you 3 hours. I'd love to, but I can't throughout the day. Let me know and let me think about it. And then sometimes I have people come in for an initial consultation, of which there sometimes is a cost, sometimes there isn't. In the pandemic world, where that's really not a possibility right now, I usually give people a lot more time on the phone. And again, I don't charge them initially. So sometimes I'll speak to you for half an hour, 45 minutes, getting the rundown, getting the lowdown. And sometimes we might have a Zoom call. You might want to see the person that you want to retain. I don't blame them. This is what I look like. Can't do anything about it. I'm sorry. I'm not as pretty as Furley and Carolina, but I do my best. And I say, but, upon that, I say, look, I will guide a client. I'll say, I think they have a case or they don't. I never want to lead a client down the wrong path. I never tell them what they want to hear, as much as I'd like to. So if you call me and you want me to tell you what you want to hear, you're not going to be calling the right person. I'm going to tell you how it is. I'm not going to be rude about it. I'm going to tell you every angle that possibly exists, but may not. And that sometimes happens. But if I think there is something that can be done, if I think there is either discrimination, retaliation, a breach of contract, a wage and hour issue, a restrictive covenant issue, which also comes up a lot, I have the client sign a retainer agreement. I don't charge a very high hourly rate compared to my colleagues. I'm very competitive in that regard. I try to be mindful of the person's pocketbook and their budget. I'm not trying to break the bank on you. Lawyers have a tendency or a reputation for billing very high rates. We don't all bill high rates, but people sometimes underestimate the amount of time that has to go into a matter. And even if you bill at a very low rate, if you're putting in dozens, or if you're in a litigation, hundreds of hours, the bill can add up after a while. And that's not, we don't do that to kill you. I know Carolina is very cognizant of her billing. She always told me, since we were at Bud Larner, how she's always mindful of that fact. And matrimonial lawyers sometimes get a very bad rap about it, but Carolina is very good about it. And that's one thing, many things about Carolina that I like, is that she's honest with her billing, which is crucial. But if it's there, what I usually do, if it's an employee, I'll write a letter to the attorney, or I'll write a letter to the business, hoping that an attorney will get it and then call me. If it's an attorney that I know is on the other side, and I know a lot of attorneys, fellow employment and labor attorneys, I say, you know what? Let me give them a call. Let me call John. Let me call Susan. Let me call Bill. They know me. They know, I'm not a BS artist. They know that I'm serious, but they also know that I'm going to give it to them straight. That's sometimes the best way. And sometimes interpersonal relations between attorneys is the most important thing in a case, because although my client may be difficult, their client may be difficult, we can work through the BS together and work out a resolution. Hopefully, it doesn't end in litigation. I say that's the last resort, because when you go to litigation, it means you were unable to resolve it, and further settlement discussions are not going to go anywhere. And the only other choice is to go to litigation. You hope it doesn't get to that, but the good news is this, and Carolina can attest to this as well: the vast majority of litigations settle. Nobody wants to go to a jury because it costs too much. And once you're in front of a jury, basically all bets are off. A jury, as much as they're charged on the law and told what the law is, juries go by the heart. They don't always go by the head. They go how they feel in their gut. And you never know what a jury is going to do. So at the end of the day, the goal is to seek a resolution and to put the employee, or sometimes the employer who I'm representing, in the right position to move on from it, to chalk it up as an experience and to learn from it and to move from there.
Carolina, would you like to talk about divorce dynasty? Because obviously, look at the Josh Weiner. I got it right this time.
I got it right this time.
Yeah, it's like he's obviously one of our vetted professionals. Please talk about the divorce dynasty and how we actually impact the lives of many people out there.
So, Divorce Dynasty is a concierge platform made up of vetted professionals, doctors, lawyers, bankers, realtors, life coaches, insurance professionals that all step in to plug in their need in the divorce process, which is now extended into death of a spouse, disability of a spouse, death of a child, etc. When life throws a curveball and you're lost in the process, you don't even know where to begin. When something bad happens, we go into panic mode typically. Very few of us say to ourselves, this is terrific, let me problem solve this. We are emotionally driven at the time, probably psychologically broken, scared financially, and we don't know what to do. In response to my own divorce several years ago, I identified that that was not the time to start getting my act together. So Divorce Dynasty was formed to help people problem solve when they feel at their weakest. And I could tell you that employment is a huge issue in the divorce process, whether you are looking to get a job, about to lose your job, or as we talked about today, you have a family company that you need to now unfold, undo, sell, etc. So we are here constantly on the Divorce Dynasty platform thinking about what additional professionals we need to bring on board. So when Johnny, Sally, Bobby, whoever calls us, whether you're black, white, male, female, whatever you are, we want to be the solution. And the wonderful thing about the Divorce Dynasty platform is that it saves you money, because rather than going to your divorce attorney and talking to me about everything under the sun, including the custody of your cat, I am now linking you with people that could help you, and you go deal with them. You come to me for the divorce, for the legal, but go talk to Josh about the employment issue. It's
and these are all trusted professionals who have been carefully selected and invited into the platform. So you know for a fact that you are going to be getting the best services, and people with integrity and people with the greatest of hearts. And that's what I love about Divorce Dynasty. By the way, somebody had told me about, we just had a spread on the industry magazine on the centerfold, and actually somebody, one of my relatives saw the magazine and said, like, how did you get in here? They were very impressed about how these top-notch professionals have gathered together and have this incredible photo shoot. Basically, like, what a beautiful spread, and also a great advertisement of these are the people who are out there looking out for the best interest of the client every single time. So I could not be more thrilled to be part of the Divorce Dynasty and the D word. And Josh, oh my goodness, you have given us incredible content and value today. And we could not be more grateful for you. And how can people reach out to you if they need to get your expertise?
Sure. And like I said, I'm the head of the Labor and Employment Group at Coughlin Duffy. We're located in Morristown. It's COUGHLINDUFFY. You can call me. My direct dial 973-631-6020, or you can email me. That's probably the best way to reach me is by email. Is J, so letter J, Weiner, WEINER, at CoughlinDuffy.com. So it's COUGHLINDUFFY.com. Jay Weiner at CoughlinDuffy.com. When it comes to emails, between my phone, my laptop, and everything else, I will get back to you undoubtedly in less than 24 hours. Sometimes instantaneously if I happen to have my phone in front of me. If you call me, it might be a little longer because I may not get my message right away. So email's the best route.
That's awesome. Any last words, Carolina and Josh?
Well, I was just going to say that anybody could always contact myself or Furley, and whether it's through Facebook Messenger, my cell phone number is all over the place. Everybody could always reach me for anything. We will put you in touch with any professional on the Divorce Dynasty platform that you need to talk to. And I can tell you that similar to Josh, Furley, myself, we are on 24/7. We will do our best to get back to you. And if we are not the professional to help you, our network will be reached to find the right fit for you. I just want to end by saying this. When your foot hurts and you go to the internet and you Google, foot pain, next thing you know, within 20 minutes, it's got to be amputated, you got to lose your tongue. Yeah. The internet is a dangerous place. If you want to do a little shopping, look at the lipstick trends, I get it. But if you're going to be thinking about divorce, life insurance, employment law, losing your job, I'd steer clear of that. It's very important to speak to the right person who does this for a living, and in 10 or 15 minutes could explain to you what you need to know, because otherwise you might be amputating your own foot at home. So Don't play doctor, don't play lawyer, don't play insurance agent. Talk to the right professionals.
Exactly. Carolina raises a very good point. I always say the internet is a very wonderful place, but it is a very dangerous place. I've told people, I said, look, don't do self-help. You're not your own doctor. The analogy Carolina used is perfect. They said, if you're sick, you might go on WebMD and all of a sudden you think you have cancer. You might think you have literally everything under the sun and you're about to die. You call your doctor and you let your doctor handle it. Don't self-help. You can learn, know your rights, but always seek clarification from professionals. They're there to help you. It's what we're doing. It's why we went to school for it. It's why we put up our shingles. It's why we put out our name, so we can help you in that regard. And secondly, and Carolina raised this point very well, don't let emotion dictate what you're going to do. People do knee-jerk reactions all the time. I always am very emboldened when someone calls me when they're in that position. I calm them down. I talk them off the ledge and I say, look, this is a business decision. This is a life decision. If you're emotional about it, you're not going to make the right decision. Revenge is a dish best served cold. Let a professional help you. They're going to make the right decision because we're objective. We care about our clients. We're there. We empathize, but we have to be a little bit distant and a little bit colder because we have to be able to make the right decision for the client. You're not going to be able to make that decision for yourself because it's you, and your judgment's going to be clouded. Use a professional for it. That's why we're here, and we're here to help. And this platform, Divorce Dynasty, is a great resource. I've met all the individuals who are on it. They're all solid professionals, extremely impressive individuals, and they can help you. They absolutely can.
My goodness, I could not have said it any better. This is not a do-it-yourself type of thing. When it comes to your sanity, your health, your future, your legal rights, you want to reach out to the professionals because it would cost you more by making the wrong action.
It's a very good point. Absolutely. Right. It will cost you more in the long run if you decide to do it on your own.
And believe me, I've learned many times the hard way because you try to do shortcut, but shortcut could be very, very costly because you are not being guided by the right professionals and experts. On that note, ladies and gentlemen, I hope you were able to get a lot of information again from the D word. Until next Saturday, this is Furley Almonte along with Carolina Denhard and Josh Weiner. Thank you so very much and make your weekend spectacular. Take care now. Bye-bye.
Thank you.
Thank you, everybody.